Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
Good afternoon, everyone. Welcome. Glad to have you all with us. My name is Joel Cundick. I'm a financial advisor at Savant Wealth Management. I'm based in the Vienna, Virginia office, and I'm joined today by Alaina Davalos, who is one of our wealth transfer advisors, and she's down in Atlanta. So we're excited to be with you. Good to be with you today, Alaina.
Yeah, thanks, Joel, so much for having me. I've seen a lot of questions come up lately about this topic, how to be an executor. So hopefully today we'll be able to answer some questions and provide some information about that.
Great. So, and one of the things we encounter when we do presentations like this is how to serve as an executor can have two meanings, right? There's the idea of how do I be an executor, and how do I prepare family members for being an executor at some point in the future? So we're going to try and cover both lenses today, a little bit from each side. So we're going to cover the roles of an executor and trustee. We're going to talk about some must-have financial planning documents, estate documents, and then we're going to go through some beneficiary asset titling decisions. You're going to see this is broader. You have to have a sense, right, of how the whole estate plan operation works in order to be able to do a good job at either prepare your family member or prepare yourself to be an executor. We'll go through some important tax filings and promoting family harmony to wrap up, and we'll see if we can give any great ideas there. This is a balancing act, right? When you try and develop a good estate plan, you're trying to keep yourself independent as possible, and you're also trying to get assets as much as possible to the next generation in a way that works best for your family. Sometimes the ways that you think you want to leave assets to your family and the way they'd like to receive assets don't align with one another. So that's an important factor to consider as well. So we're going to navigate that as estate planning balancing act. And Alaina, why don't you kick us off talking about the roles of an executor and a trustee.
So before we dive into the details about serving as an executor, I do want to remind you that, estate planning, probate, trusts, these are all subject to state law. So, while we're going to talk generally about these topics, please know that you should also consult a local attorney before engaging in any of these activities. And so, now let's start with the basics. What exactly is an executor and what is their role? So, I found that throughout my time in private practice, most people's perception of an executor and the probate process generally comes from TV. On TV, there's a gathering of the family in the lawyer's office. Everyone is waiting with bated breath to see what they're going to inherit. The executor is announced, and it's not who the family expected. It's all very dramatic. In reality, there's usually not a spectacular event. A person who passes away is called a decedent, and that decedent either had a last will and testament or they didn't. If they had a will, it most likely named someone as the executor. The will may also refer to that person as a personal representative or an administrator. But for our talk today, just like the theme of the webinar suggests, I'm going to use the term executor. For the family to first find that will that names the executor, it's usually going to be with the decedent's personal effects in a safety deposit box, or it's with the drafting attorney. Most wills today are written in modern English and are relatively easy to understand. There can be a lot of language in the document itself. I may have drafted a 50-page will on occasion, but identifying the nominated executor is usually pretty easy. The executor, however, is not automatically in power. Let me repeat that. Just because someone is named in the will as the executor does not mean that they immediately have the authority to act on behalf of the decedent's estate. And why is that? And that's for starters, the decedent may not have a probate estate, meaning that there are no assets that the will controls. A will, and hence the executor, only has authority over assets that were in the decedent's name alone at their death or directed to the estate via a beneficiary designation. The will does not control assets that had a joint owner or a beneficiary designation. Common probate assets include real estate owned in the decedent's name alone, checking and savings accounts with no PODs, which stands for payable on death, and brokerage accounts. This is not a complete list by any means, but these are the most common. So let's say, though, that the decedent had at least one of those probate assets in their name at their death. They also had a last will and testament. How does the executor gain their legal power? As I mentioned, this area of law is state specific, so each state has their own rules and regulations about going through the probate process. The American Bar Association defines the probate process as the formal legal process that gives recognition to a will and appoints the executor or personal representative who will administer the estate and distribute assets to the intended beneficiaries. Generally, the decedent's heirs at law and the beneficiaries under the will, who may or may not be the same people, have to be notified and given an opportunity to object to the validity of the will. If there are no objections, everyone agrees, the court will issue the executor the legal documents authorizing them to act. The court may also require the executor to post bond based on the projected value of the assets in the estate. They may have to file an initial inventory and or provide an annual accounting every year that the estate is open. So do keep that in mind. If you are ever named as an executor, make sure you check or ask your attorney what the court is requiring of you.
Alaina, how much could they be expected? Just we talk about bond. I mean, sometimes people get very concerned. What dollar amount threshold? I mean, range are we talking about?
So I have seen bond posted for a few, let's say $50,000. They would have to pay a bond based on how much that value is. I've seen bond posted for $1 million. I've seen no bond required for a $5 million estate. It really can be all over the board. And shopping around for a bondsman is something that it is an option. There are different bondsmen out there. You can work and see who's going to give you a better price for your bond.
So this is not all cash out of pocket, though, is what with the bottom line here.
Correct. No, it's usually a policy. So that bond is similar to an insurance policy to make sure that those assets are going to be covered while you're managing the estate.
Great.
So once the executor has those legal documents, they've supplied that bond if they're required. You can see here on our screen, you see the usual process. Once the executor has filed the will with the court, they've got to administer the probate estate. They've got to collect the bank accounts, get appraisals on real estate or list it with a realtor, notify business partners of the decedent's death. The executor also must notify, generally, any of the decedent's creditors of the decedent's death and pay final expenses. That can include funeral bills, costs of administration, such as legal and CPA fees, and pay the final taxes, which we'll talk about in a little bit. The executor is also legally responsible for filing any tax returns that are due, which again, I'll talk about in a minute. Once all those debts have been paid, the executor will distribute assets according to the terms of the will to the beneficiaries. Then, finally, once all of that has been completed, the executor can formally close the estate. Closing the estate generally releases the executor from any further liability related to their role as the executor. They're done. They are hanging up their hat saying, that's it. Don't spend your inheritance all at once. I'm kidding, but you get the gist. So while this sounds relatively simple, and it can be, there are also aspects of being an executor that can make it an undesirable job. Um, Family conflict can make this not so fun. Taxes and unusual assets like business interests, oil and mineral rights, any out of state real estate can make this a very difficult job. With good planning, though, on the decedent's part, the executor role can be a short term role that keeps the family harmony and sufficiently and succinctly distributes the decedent's assets. On the flip side, though, usually an executor can get paid. Either the will or state law will dictate what the executor is entitled to for doing all this work. So make sure, either if you're creating your own will or acting as an executor, you're aware of what those fees are. So the other role that I see a lot of confusion with, a lot of blending of the terms, is a trustee. And so I wanted to clarify the differences between an executor and a trustee because I see a lot of clients that use these terms intermittently, even though they do have separate meanings. So a trustee is someone who holds assets in trust for the benefit of a beneficiary. A trustee is not usually nominated by a will and then appointed by a court. A trustee is generally named under a trust agreement. And so for our chat today, just to keep things simple, I'm going to just refer to a revocable living trust, not an irrevocable trust. A revocable living trust is a tool that is created by a person called the grantor or the trustor to hold assets in trust. Generally, the grantor is the initial trustee, the initial beneficiary, and the trust uses the grantor's social security number. The primary purpose of the revocable living trust is to avoid probate at the grantor's death. Because, unlike the grantor, a human, the revocable living trust does not die, so assets that it holds do not need to go through probate. The revocable living trust is funded two ways, either during lifetime by the grantor themselves or at the grantor's death via the probate process. That's right. Sometimes an executor will have to go through the probate process in order to transfer assets to a trustee. A lot of times, the executor of the will, which when you combine it with a revocable living trust, is called a pour over will, and the trustee of that revocable living trust are the same person. That makes for a smoother transition of assets if the pour over will needs to go through probate. So the trustee's role is very similar to the executor. The trustee is responsible for administering the trust, collecting the trust assets, whether that's from the probate estate or assets that name the trust as a beneficiary. The trustee then pays any taxes, debts, or administration fees not paid by the executor. Sometimes, however, a revocable living trust will not end. Instead, it will morph into an irrevocable trust. In the graphic you see on the screen here, we've got a revocable living trust that changes into a trust for the survivor, which in this case is the surviving spouse. At that surviving spouse's death, the trust changes again into subtrust for the children. Those children's subtrusts are generally irrevocable. If that is the case, if the trust fund is just not simply paid out to the trust beneficiaries, then the trustee has additional duties. They'll continue to manage and invest the trust assets on behalf of the beneficiaries, approve any distribution requests, and file any annual trust income tax returns that are required. They'll also make any mandatory distributions that the trust agreement dictates, such as 1/3 of the trust when the beneficiary reaches age 25 and the balance at age 30. Whatever the trust says, the trustee must do. As opposed to being an executor, being the trustee can be a long-term duty. So make sure you're aware of that if you're nominated as the trustee. And again, it's very important to differentiate between these roles because they're controlled by different documents. The trustee is subject to the terms of the trust agreement, and the executor is subject to the rules of the court and the terms of the will.
So it sounds like, Alaina, that one of the things we got to prioritize here, if we're looking at being an executor or making it easier for someone to be an executor, is to get all the assets together in one place and look through their titling. Because anything that's going to be titled to that trust is going to be according to the trustee, and anything that is titled outside of that, it's going to be executor's function. Have I said that right?
That's correct, Joel. Good job.
Yeah, so one of the things as we're contemplating this role, and let's say we're talking to a loved family member who we think we're going to be an executor for someday, it would be a really good idea to have a conversation and say, hey, I know I'm going to be your executor. I'd really like to know what your assets are in advance. You don't have to tell me the balances, but even just tell me where they are and how they're titled. Because that piece of information is often going to point out something like, as you have said, Alaina, maybe we've got an asset that's titled personally, when really what we want is it titled inside the trust, because there's a trust. And if we can send it to the trust before death, then it can distribute to heirs efficiently after death without going through courts. If it's still titled in the estate at death, now we've got to go through probate to route it into the trust. Is that correct?
That is correct.
Okay.
Joel, can you tell us a little bit about those necessary estate planning documents that'll get us there?
Yeah, it's a good idea to have a sense of, all right, what are we playing with? If I'm trying to work with someone who I'm going to be an executor for, or I'm trying to make things easier for an executor, what are the documents that are going to come to play? One is the power of attorney for property. And a power of attorney for property is effective before someone's death, not after someone's death. So the second that someone passes away, that power of attorney is really, it can be shredded. It's just not relevant anymore. But until that point, you can get a situation where someone you are going to be an executor for someday has become unable to manage their personal finances. The only document that is going to allow for you to step in and handle their financial affairs for them is this power of attorney for property. This is a strong document. It says here, use statutory forms when possible. Sometimes states have like a statutory power of attorney form. You could just say, here's who I designate as my power of attorney and sign it. But it's according to state law, and it designates someone to act on your behalf when you can't act on your own. It's a very powerful document. So if you're giving a live power of attorney to someone else, you're putting a high degree of trust in that person. They can enter into a contract, buy real estate, take out a loan, sell real estate. There's a number of functions they can do with that power of attorney for property. It has to be that kind of power in order to be helpful when you're incapacitated. I'll also put a footnote here that even if we're trying to use trusts to govern everything and maybe have a successor trustee who can act on my behalf on all assets, if I've got an IRA, this document, the power of attorney for property, is the only one that's going to allow someone to transact on my behalf. IRA, retirement plan, 403B, all of those retirement vehicles, it's going to have to be a power of attorney for property. And in many states, it's going to have to specify, I authorize my power of attorney to transact in my retirement plan or individual retirement account. So this is a really important document to have in place. If you are contemplating being an executor someday, ask somebody pull out their estate documents. This is one of the ones you're looking for to see what it says. You want to name multiple individuals in here. And typically we want to name them in succession. not in concert. Anytime you name people in concert, now all of them need to come together to act on my behalf, and all of them need to be in agreement about what happens on my behalf. It may be that that's what you want, but know that that adds a degree of complexity that can be tricky. But we do want definitely multiple tiers of a successor agents. And the reason for that is we want this document to be as flexible as possible. If I die and my daughter, who I've named as my power of attorney, is living over in England, and it's not effective for her to be able to transact, it would be good for me to have my son named as the successor agent so that he could then transact. All right. The other thing we want to make sure, if you haven't dusted your power of attorney off recently, including digital asset authority was not really relevant 20 years ago, and it's critical now, right? We all have online accounts. It's important that we tell the powers that be that I authorize this person to make changes to my digital accounts. Okay. That's
One thing
document.
that I want to, sorry, Joel, don't mean to interrupt you.
Not at all.
Just, I've seen this a lot lately. One of the things that comes up. So, this document that Joel is talking about is usually a general power of attorney. It's giving your agent that authority over a wide range of your assets. And that can be very different than, let's say, a power of attorney you had to sign for Schwab, or for someone else who's managing your accounts. You may have had to sign a power of attorney for a real estate transaction. Something like that is where you see those a lot. So this document is going to be general. This is either going to come into effect now, or it could come into effect while you're incapacitated, giving someone else that broad range of authority. So just because you may have signed a power of attorney at some point does not necessarily mean it's that same power of attorney that you need in your overall estate plan.
Right. Yeah, it makes a lot of sense. There's one other power of attorney that we need to know about that is going to be important, again, prior to death. And oftentimes these roles can, match up. That the person who's going to be named as an executor in the future is first going to have to go through some stages of being a power of attorney. So there's a power of attorney for healthcare and advance directive. This used to be called a living will in some way. Oftentimes a living will is integrated into this. The idea behind this document is I'm specifying what I would like to have happen if I am hooked up to machines and I cannot make decisions on my own. And it will list a set of predetermined possibilities, but it also goes forward and says, there's things that I can't contemplate here that may happen to me, and I might be incapacitated and unable to decide for myself. Here is the person that I nominate to act on my behalf when I cannot make decisions for myself. So power of attorney for property was step one. That's all our financial aspects. Power of attorney for healthcare. This is a limited power of attorney, kind of like Alaina was referring to, that only speaks to what someone can decide on my behalf related to medical decisions. This is a document I want to have on file with my primary care physician. It's a document I want to have at the top of my estate documents. You never know when something is going to happen. You become incapacitated, and the people you love cannot act unless they have it. I will also add, it's actually the most important document to put in place when your children turn 18. Because the second they're 18, HIPAA laws prevent other people from being able to make decisions or find out information about someone who may need medical assistance. I may or may not be speaking from personal experience with a child having an appendectomy during her freshman year of college. This is a very important document to have in place, and oftentimes you don't think about it at the ages you might need it. All right, so we want to have a copy of it with the physician. We want to think in advance of how we would like things to be handled if we could not make medical decisions for ourselves. And the thing I'll add to that is we want to have conversations about that in advance. We want to make sure that the people we've named, when they make those decisions, are very comfortable with what we said that we wanted, right? So again, we want to have multiple agents named if possible, so it can be flexible. But these are the two things that we use before someone passes away. Now we've got the two documents after someone passes away. which we've referred to in concept already. I'll just refer to them quickly on the next slide. We've got wills. This is the last will and testament. Anything that I have not named a beneficiary to, which would be an IRA, a life insurance policy, an annuity, all those things I name beneficiaries. So they're not going to pass by the will. Another thing that as we're contemplating being an executor, it might be good to review. In fact, if I give one thing that I'm trying to make sure people get in order with their personal finances related to estate planning, it's to pull the beneficiaries of all accounts that may have beneficiaries. They're, like I say, their life insurance policies, their 401ks, their IRAs, their annuities. You want to know who you have designated to transact, to receive those assets at your death, because it's not going to pass by will. All right. The will does one thing that no other document can do as well. Well, two. Names the executor. We already talked about that. It also nominates guardians for minor or incapacitated children. It's the only document that can do that. So as soon as someone has children, they need a will. It's critical because you do not want the state making the decision on your behalf. You don't want your family to have to figure out how are we going to coordinate this. You want it all predetermined, named in the will. All right. It can be coordinated with a revocable living trust. We've already said via pour over provision means anything I haven't named to my trust that's in my personal estate, I put into my revocable living trust at my death. The trust's power is that it avoids probate, which means that it keeps your assets private. That's not a matter of public record. And it can also transfer more efficiently. Some states, wills being probated can take 9, 12, 18 months. Generally, revocable living trusts are much more abbreviated processes to administer because they're handled by a trust document, not by a court system. Oftentimes, we, as we said, as Alaina said, maybe the trust is going to continue beyond our death. So this is another factor. If I'm thinking of being an executor, I want to know what are the ongoing provisions that are going to work after someone passes away, so I can know when I coordinate with the trustee on people receiving assets. I can just, everybody's going to turn to the executor. They're all going to have questions. What do I get? When do I get it? How are my parents' assets titled? Everybody kind of starts asking these questions and they start pushing too, right? This is a very stressful time for the family. It tends to be that a lot of people's, tendencies come out more than ever. Their long held grudges can come out whenever. We want to make sure we're doing the best we can to name people to transact on our behalf who are going to handle things in a measured way, well documented, so that they can convey important information to the other people involved in this estate process, and they can keep the process moving, because there's going to be critical stages for action that they need to be ready to go to the courts, sign things, coordinate with the attorney to move things forward.
Joel, I think you touched on this a little bit, but let's do a little bit deeper dive into the beneficiary and asset titling decisions. Just because this does have such a big impact, not only on a person's estate plan, but especially at their death. So here is a sample estate plan like what Joel just discussed. And I hope you guys like this chart because this is what I normally spend my time here at Savant doing every day, which is reviewing documents and preparing graphics like this for our clients to see how their estate plan is going to flow. So in this example, we have a joint revocable living trust. It's been funded with some assets, the trust brokerage and the home. And then there are still some assets that are passing by beneficiary designation and some that are passing by joint ownership. So this is where I see a lot of family disconnect happen because of poor planning. For example, family members will blame the executor or trustee for how the IRAs are passing. Unless the estate or trust is named as the beneficiary of those accounts, the executor or trustee has no control over them. Any issue that arises is because of poor planning on the decedent's behalf. And well, their concerns are over at this point because they're dead. So Going back to this graph, again, this is a relatively complicated trust with spousal subtrusts and lifetime trusts for children. If you've worked with your attorney to come up with this plan, that's step one, getting those documents in place. On the next slide, you'll see step two, which is trying to figure out the beneficiary designations, which, especially with qualified retirement accounts, can get very tricky. And so you'll see those IRA accounts, which normally make up a significant portion of most Americans' estates, have several options for beneficiaries. Joel, can you give us a little bit more details about how and why to pick those beneficiaries on qualified accounts?
Yeah, there's been a lot of changes made here over the past few years to the laws that relate to how an IRA transfers and how it is distributed by the recipient. So what we have here is the option to name people as outright beneficiaries, or we have the option to name a trust as a beneficiary. That's going to sound a little bit weird because I just said that I can't title an IRA to my trust. I have to hold on to it personally. I can't route it through there. Yes, I can't title my own IRA to my trust. However, I can leave my IRA to a trust so that when my inheritors receive it, there are limits on the way that they can receive it. All right. The big change to the Secure Acts put in place was that where a beneficiary used to be able to take distributions out over their entire lifetime, right? Their full life expectancy. They now have a consolidated amount of time, 10 years. All assets need to be distributed from an IRA within 10 years of someone's death, all right? That fact has really changed a lot of the planning around how to leave assets to kids. Because it may have been before that I was comfortable leaving something in trust to a child because there was going to be this long-term distribution, where now I might swing toward naming the child as an outright beneficiary because it's only going to be a 10-year process anyway. So that's a possibility you decide. I can't tell you what is the right or wrong thing. It's going to be dependent on the family. But when I leave an IRA to my outright beneficiaries, that is a pretty simple process. The executor in handling my estate would gather the names, dates of birth, addresses of all of the beneficiaries. They would coordinate with the custodian, whether that be a brokerage house or a bank, to get all of that information to them and create accounts for each one of these beneficiaries. And then they sign off. The beneficiaries receive the assets and the executor's role is done. When you do that, there's no asset protection. So the amount that has been left to that beneficiary is available potentially to their creditors is a concern. There's also concern that they may spend it too fast, right? You might be concerned about how much money inheritors get at a time. It's potentially more income tax efficient because it has a great deal of flexibility. I'll give an example. If someone is trying to get their kids through college and they're relying on financial aid, and their parent passes away, and now they have 10 years to get an IRA out, where otherwise we may just say, hey, take roughly a tenth, a tenth, a tenth, a tenth each year. Now we might say, hey, let's get that distribution as low as possible in the early years while you're trying to qualify for financial aid and raise the distributions to higher amounts in future years. So that outright leaving can make things more tax efficient for the beneficiary. Now, we'd use the trust. It's more complex. It's going to be a more lengthy process. It is going to have an ongoing trustee who's administering it. It's going to have its own tax return, but it's going to give greater asset protection. So particularly where we have children who have special needs, if we have concerns about, our child getting divorced and we don't want spouse to have an access to funds, we're in an IRA, so it's kind of a sheltered asset, but while somebody's married and the distributions are coming out, you can't control how they're coming out. So this idea of leaving in trust with more restriction can be desirable to families. So when when we think of that though, all right, then what's next, right? So how would I want to choose of these two? I'm going to want to leave in trust when it's a very large balance and I'm concerned about the size of the balance in the hands of the beneficiary. I'll give an example. When there is one child and the IRA balance is $3 million. And we're concerned the child is 22, not certain how they're going to be able to handle that much money all at once. Maybe we leave in trust, right? If it's a young beneficiary, maybe we're going to leave in trust. If we're concerned about asset protection, maybe we use trust. But all of this is going to be a matter of weighing advantages and disadvantages. And so we can't talk definitively about which is the right answer here. But certainly, as you're looking at acting as executor for someone, this is stuff you want to understand. How are assets set to transfer, and have they made the right decision that works for them and the family structure? There's two kinds of trusts that can be.
Hold on. I'm gonna pop in real fast. Just something else that
Absolutely.
I wanted to mention about these trusts. You know, if you're looking into incorporating them as part of your estate plan, there is a lot of flexibility generally under today's laws. You know, these trusts can be as restrictive or as flexible as you like. I have seen a lot of clients that are very cautious of using trusts. I think they've got a very bad reputation, sort of that hand controlling from the grave. And so, but just know that trusts do provide a lot of protection and can be used in a multitude of services. So if you're thinking about it, don't be scared. Talk to your advisor. Ask, is a trust the right tool for me and my family?
Many situations that are. Yeah, no way do we want to discourage them and say that these are not good vehicles. They can be very appropriate for certain circumstances. As we look at the kinds of trusts that come to play specifically with regard to IRAs, we can have two kinds. We can have a conduit trust. And the idea on a conduit trust is all the withdrawals go directly to the trust beneficiaries. Parent leaves assets to a child. Child it has an inherited IRA, but in through trust. But when any distribution comes out from the trust, it goes directly to the child, and that income as a result is going to be taxed at the beneficiary's tax rate. Then we can have an accumulation trust. Accumulation trusts are pretty important in a circumstance of a special needs child where we're trying to not have too much assets titled in that person's name. The idea in an accumulation trust is the assets in the inherited trust IRA distribute out from the IRA, but are then deposited into another trust account. It's all done within the trust. That means we can retain the assets in the trust, and we can have more flexibility about when funds actually go to the beneficiary. That said, we now have to deal with trust tax rates, which are nothing like individual tax rates. Individual tax rates, we don't get to 37% until we're in the multi-$100,000 of income level. Trust tax rates rise to 37% at around $20,000. So we're potentially going to expose the IRA to a lot more tax if we retain in the trust. That doesn't mean it's not the right thing to do. There are circumstances where it's appropriate. And this is, again, something, if you're contemplating being an executor, these are things that you want to understand about how assets are going to transfer and what an ongoing responsibility there's going to be.
So, speaking of taxes and your responsibility as the executor and the trustee, there are a few important dates that every executor or successor trustee should know about. Um, so the first is going to be when the decedent's final income tax return is due. And as I'm sure most of you know, that is April 15th of the year following the decedent's death. That deadline can be extended to October 15th, the same as anyone else's taxes. The same deadline can apply for the estate income tax return, which has to be filed for any income earned by the decedent's assets after their death, but before they're distributed to the final beneficiaries. So as long as it exceeds a certain threshold, which is currently $600. If the estate is open long enough, it's generating income, whether that's from a brokerage account or from a sale, it may need to file an income tax return as well. You've also got the same rules for a trust income tax return. So if you're the trustee of a revocable living trust, the grantor passes away, and the trust assets earn more than $600 in 1 year, the trustee will most likely need to file a trust income tax return if that income is not distributed out to the beneficiary. One final return that the executor or trustee may need to file is the decedent's federal estate tax return, which is the Form 706. So this return is due 9 months after the decedent's death, and it has an available 6-month extension. So unlike returns with a calendar year, this return is based off the date of the decedent's death, and that is important to remember. Generally, an estate tax return is required when the decedent's assets at death, combined with the value of any taxable gifts they made during their lifetime, exceed the decedent's available estate tax exemption amount as of the year of the decedent's death. The exemption amount is subject to change with Congress. It is currently $13.99 million per person. But again, that amount it can change with the law. It is currently scheduled to sunset down to about $7 million at the end of 2025. So many more estates will be impacted. The estate tax itself is about 40% of all wealth over the exemption amount. A 706 estate tax return may also be required if the estate needs to make a portability election. Portability is when the decedent's available estate tax exemption is ported over to the surviving spouse. This can be beneficial because it can allow the surviving spouse to give more assets to beneficiaries at their death without having to pay additional estate taxes. If the decedent's estate only needs to make a portability election and the estate does not owe any estate taxes, there is a new 5-year rule to make that portability election. This has been a really great change to the law recently. And so if you or someone you know, if their spouse died within the last 5 years, seriously consider whether filing a 706 to make that portability election would be a good idea for your estate. That's a good question to run by your CPA, run by your attorney or advisor. So there may also be a state estate tax return that needs to be filed as well. Again, make sure if you're acting as the executor or trustee of an estate that you confirm with your attorney or CPA when, if any, the state estate tax is due. So the last thing that we sort of want to cover is how to promote family harmony. Because, as Joel mentioned before, when someone passes away, there's some tension can arise. Even if there's a good plan, family tension can come from the worst of things. And so, Joel, what's your advice for promoting family harmony?
All right, just leave me the real easy one here, right, Alaina? All right, we all got 90 minutes, I assume, for me to go into, promoting family harmony. This is a tough topic. And I will tell you, I have a one-word answer if we don't have much time. We do have a little time. I'm going to go in more depth. But the one answer one-word answer I can give is communication. There is far too little of putting cards on the table in the estate planning process within our culture. This is not true with all cultures, but in the United States, generally, there is this idea of, I got to keep that close. I got to not tell anybody. I don't want anyone to plan on receiving money from me, or I don't want to deal with the complex emotions of the person who's an inheritor in a different way than they think they ought to be. If we can leave assets however we want, right? And we can certainly wait on that decision for anybody to know about it until after we're gone. But if the goal is family harmony, then as early as feasible, it is good to share conceptually the ideas in an estate plan. If you're potentially acting as an executor for a parent, it would be good to try and initiate that conversation. First, privately with them, perhaps, then maybe with the broader family if you can convince them. If you're thinking of somebody being an executor for you someday, it would be good for you to initiate that conversation, to take some time, sit down together, have lunch, and talk about, hey, here's the general things that I am planning on doing here. Here's what I'm trying to accomplish. One of the best tools for promoting family harmony is the document that Alaina talked about earlier, where you can see how all assets are flowing. It's the best way to spot potential inefficiencies. I've seen a case where, one spouse had a very large pension, the other spouse had a very large IRA, and there were children from previous marriages for each. That we saw when we diagrammed these things out that actually assets were not transferring the way that they wanted them to. It depended on who died first. And so getting this flow of how assets transfer helps you see things more clearly, how everything's going to work. So you can head things off potentially where you say, wow, that's not what I'm intending at all. But then let's say you have one child that you're going to leave assets to in trust and one child that you're not going to leave assets to in trust. That's an important conversation to have. If you choose not to have the conversation, that is your choice, but you do need to know the likelihood is there will be extensive tension at some point related to that decision that you've made. So getting clear on what you want to have happen and then communicating that with everyone is the best way to increase the odds of family harmony. Having everything in order, having everything in one place so that it's simple for the executor to pull things together and get answers to heirs is also very helpful. If documents are spread out all over the place, if we have 20 different investment accounts, if we have property in multiple states but no address is listed, the role of the executor is extensive before they can even tell the family anything. And as the family is then worried what's happening, how I don't understand, the executor just kind of has to say, I'm not there yet. I don't have a handle on how everything's going to work. I will get there. That promotes tension, right? So there's the best thing we can do is be organized and be communicative. Now, one of the best tools we know to get organized is we've built an estate and trust administrators guide. This is going to be emailed to everyone who participated in this webinar today. It's going to be emailed afterwards, 1 to 2 days after this webinar, so that you can see a guide. It's kind of a collation, if you will, of all the questions that we've seen over the years at Savant that people think, man, it really would have been good for us to know this in advance about our parents, or to tell. I really wish that I had known to tell these things, right, to my family. About 10 or 13 pages of questions that may not all be relevant to you, but help consolidate into one place all of the important information related to your estate. All right, so I think the best thing you can do is communicate.
With that, with the communication, one of the big things to remember is with estate planning, sometimes you have to choose your priorities. Sometimes, you have a tax efficient decision to make. Sometimes it may make sense to name your spouse as the beneficiary of your retirement accounts, and that could be to the detriment of your children. But you chose that tax efficiency over sort of protection for them. So this can also give you the opportunity to explain that to your family, a little bit of the decision making that went into this process. And again, just as Joel said, and I don't think we could reiterate this anymore, open and honest communication.
Yeah, and we have a couple other bullets on here. We talk about personal property memoranda. This is really important to have conversations with family members about what of our personal stuff they're really going to want. And potentially to handle some of that in advance of death even. I speak specifically of heirloom jewelry, for example, right? The things that we really want to go to a certain grandchild or a certain niece. We don't want that to just be in our jewelry box in our house. All right. That we talk about another thing that can create family tension. We create a personal property memorandum. Here, how's everything supposed to transfer? There's assets in that memorandum that we don't know where they are. Not great, right? So we want to be, again, clear with our family. Here, I'm thinking of leaving this rocking chair that was carried across the plains by the pioneers to this child, right? This is a good thing to, be clear about. It's your choice, right? Your life, you can make whatever decision you want, communicate it. Ethical wills, I just will bring up briefly the idea that not all children need to receive assets equally. That is okay. Money is not an expression of love. Money is, can be used as a tool in different ways for different people. Do you have a child who is a teacher and a child who is a surgeon? You may choose to leave assets unequally. That's okay. Again, communicate it and be careful in the estate planning process when you design, deliberate about it. Like, here's what I'm choosing. To Alaina's point, you can never get everything perfect. There's going to be balancing acts, things that you're weighing against each other. So you have to pick your stakes in the ground. What matters most? What is the number one thing I want to accomplish with this? And then let everything else fill in around it. Choosing fiduciaries is a very important thing to contemplate. The person you're naming as your trustee is going to be a fiduciary to the beneficiaries. That means they are required by law to act in the best interest of the beneficiaries above their own self-interest. That's a really important responsibility. And so it's important that you carefully consider who you're going to name as that trustee. It's not just whether they're going to be a strong finance person either. It's going to be about how are they going to relate to the other beneficiaries? Are they going to be able to manage that? I think of a situation I heard of where someone was acting as trustee for a close friend for multiple beneficiaries. And the beneficiaries were so difficult to them, and the documents were so confusing that eventually they threw up their hands in the air. They said, I'm done. I'm distributing all the assets of this trust. I'm done with this role as trustee. That's not what you want when you create the sequencing of things here. So getting everything in order and being careful about who you're naming and communicative about what's going on, all critical functions.
Thank you,
So I
Joel.
think that's pretty much what we had as a subject matter. I've seen questions come through that I think we're going to have time for a few of those. If you are having questions about your personal financial situation or your potential role as an executor, please feel free to reach out to us for a 15-minute introductory call. It's been posted into the chat, the link to set that up. We're happy to talk. We love talking about these topics. I hope you can tell that.
We love to talk about this all the time.
Yeah. So please feel free to do that. We're going to cover a few questions right now, but if we do not get to your questions, please know we've noted the questions that have come in, and we're going to get back to you with responses afterward if we weren't able to cover it in the call. I've got a couple here. One I'm going to ask to you, Alaina, is there a cost to transfer assets into trusts? Is that something that is expensive to do?
So it's going to depend on the asset itself. For real estate, usually you've got a deed. You'll have a preparation fee for that deed. If you work with an attorney, you'll have possible recording fees to file it with the county. But generally, that sort of transfer is a low cost. Other assets, such as changing your brokerage account, that usually there's no cost associated with that. Because of how a revocable living trust is structured, something called a grantor trust, there are no impacts on your income tax. So there's no there's no capital gains, there's nothing income tax related when you move brokerage accounts or other liquid assets into a trust. Your bank generally should not charge you for making that sort of transaction. You may need to reconsider your bank if they do. So I would say funding the trust, it's not usually a monetary cost that you run into. Those costs aren't going to be that high. The bigger problem is usually making sure that all assets are accounted for. That's where I've seen a lot of clients really struggle, is to make sure that every asset that they have has been connected to the trust somehow, whether that's a change of ownership or whether that's that POD, payable on death designation. So that's a lot bigger issue than the monetary cost.
Yeah, this is just you pay money to create this trust, and it's an elegant document. It really matters to get everything moved into it that you want to be into it. And I did see a couple of questions about payable on death or transfer on death provisions. Those are alternate arrangements that you can use to bypass probate that don't need to go through trust. So there are other tools in the toolbox to consider. I saw here a question about, does an estate automatically go to probate? I can handle that one. An estate is not necessarily going to have a complex probate. If the estate has under a de minimis amount in many states, sometimes that's $50,000, sometimes it's $100,000, then the executor can file for a simplified probate and say, there's not enough here for you to really worry about it, I've got it. When we think about what we're trying to do with probate, it's the court saying we're going to supervise the executor to make sure that everything gets distributed properly. So on a smaller estate where you will fill out an affidavit that says this is small enough that we don't need to do a lot of complex work, maybe you're going to do it fast, but it is going to go through probate. You're going to have a probate estate generally, okay? There's a question here of what if there are assets in multiple states? Alaina, is there anything to be
My
careful
favorite.
about when you have assets in multiple states?
Mm-hmm. So some assets are very state specific, and that is one asset in particular, which is real estate. So if you have a piece of real estate, let's say one in Georgia, one in Virginia, and that asset was owned outright by the decedent at their death, most likely you would have to go through probate in both states. Sometimes there's something called an ancillary probate. Let's say the decedent was a Georgia resident, they never transferred that Virginia property. They could do an ancillary probate in Virginia. This is a very, very state specific questions, and the rules and requirements regarding how those ancillary probates have to occur, again, very state specific. But usually, if you have those two pieces of real estate located in different states, it can cause a lot of problems. One of the other questions I saw was, is it better to have sort of a will-based plan, an estate plan, or a revocable trust-based estate plan? And I will say, anytime you have pieces of real estate in different states, that's almost always when a revocable trust-based plan is called for, because you don't want, excuse me, your executor to have to go through that headache of going through probate in multiple places.
Yeah, great point. So I think it's a big topic. We only can cover so much. We hope that you feel more equipped to potentially serve as an executor or to educate someone who you would like to serve as your executor from our time together. We really appreciate your time. Thank you for joining us.
Thanks, Joel.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.